No, there's two indictments, right? I thought this said a motion to revoke. Well, that's motion to revoke probation hearing. Two MTRP hearings? On,
We got two brand new phrases.
is that right?
Probably right, Judge. Case.
Hold on. I don't see a MTRP,
I don't either.
but it's showing MTRP on the docket.
He was on probation at the time of the new office.
We may have revoked him on one already and that's on old notes. Let me look.
It's not what this shows on the file. I don't have any MTRPs in the files.
This is your fault.
It says he was indicted on these new indictments just in December of last year and January of this year. There's no way. Well, did we put you on probation in these cases?
No, sir.
No.
Not yet.
But it's showing MTRP hearings. He's not on, it's a new file. These are new files.
Let's see what this
Anyway, that's, what are we gonna do? I guess, because it's 7 months old, you're sitting around, nothing.
Just to update you, the MTRP was disposed of in March of this year. Those are just old notes that were attached to those cases, but he was sentenced on the MTRP in March.
MTRP for what?
He had a family assault that he was on probation for.
What's the number on it?
We've already taken care of it.
No, what?
24 DCCR 2199.
Okay,
And he received 10 years at PDCJ on that case.
that's right, yeah. Okay, these are two new cases,
Yes.
two brand new cases. Oh, okay, so what are we gonna do? He's just sitting around in jail and he's got a 10-year sentence out there. Sitting around in jail. Well, we gotta move these, right? One way or the other?
You give me a couple minutes to look at them. I had a chance to look at them this morning, but I'll talk to Mr. Burbank real quick. We'll see if we can't move them. If not.
Usually, your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, so this indictment alleges. Okay, what are we got? 1, 2, 3.
You need counts, you need 2 hours for 30 punishment.
Two of the bars.
Yep.
Your Honor, the state would waive the final or the last enhancement paragraph. Or abandon, I should say.
I'm sorry?
State would abandon that last enhancement paragraph.
Paragraph 1, in summary, sir, alleges that on or about March 28th, 2026 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you're charged with here? But yes, yeah, you have to speak out so she can hear you. You have to use the language. Yes, no. Today, tomorrow. Okay. This would normally be a state jail felon, except paragraphs 2 and 3 allege that on May 10th, 2011, in cause number 11,260 out of Jasper County District Court of Texas, and thereafter on October 27th, 2015, in cause number 12596 JD out of the District Court of Jasper County, Texas, you were convicted of burglaries of buildings, paragraphs 1, 2, and 3, since they're all state jail felonies. This is a state jail felony that will be enhanced by the 2 prior burglary of building convictions to 3rd-degree felony. we're writing these up on those enhancements. They've got to be what the underlying crime is. So state jail felony punished as third degree felony. So that the records show it's a state jail felony. It's just punished differently. And there is a distinction in the records. And they want that to be. Shown that way. And so you understand what you're charged with in paragraphs 1, 2, and 3. 1 being a new indictment for the state jail felony of unauthorized use of a motor vehicle, and then paragraphs 2 and 3 being state jail felony burglaries of a building convictions in 2011 and 2015 out of Jasper County District Court. This constitutes a state jail felony, though it is punished as though it were a third degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $20,000. Do you understand? Yes? Yeah, say yes, so she can hear you. Okay. An agreement's been reached in all of this that you would be pleading guilty, sentenced to 4 years in prison. Is that your understanding? If I follow this, you have no right of appeal of your case. Do you understand? So how do you plead to paragraph 1 charging you with the state jail felony of unauthorized use of a motor vehicle? Guilty or not guilty? Guilty. Are you pleading guilty voluntarily and because you are guilty? Yes, sir. And the 2 burglaries of buildings in paragraphs 2 and 3 out of Jasper County District Court in 2011 and 2015 respectively, are those allegations true and correct as they are alleged in this indictment? Yes, sir. And are you pleading true and correct to each of those paragraphs 2 and 3 of those state jail felonies? Pleading true and correct voluntarily and because those are indeed prior convictions of yours? Yes, sir. Okay. I show you what's marked as State's Exhibit 1. Did you sign those documents, understand them, discuss them with your attorney? Are the contents true and correct? State's Exhibit 1, 10, without objection admitted. This states you are mentally competent to enter your guilty pleas freely and voluntarily made. You know what you've been charged with. Indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. Yes. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, it is.
I'm going to follow this agreement if nothing further to add by the parties. I'm going to find, Mr. Dean, you have pleaded guilty and truth respectively to paragraphs 1, 2, and 3, voluntarily, knowingly, intelligently. And that is enough to find you guilty based upon paragraph 1, which states under oath that you are guilty of these offenses and you are mentally competent to enter your pleas and you understand and appreciate the consequences of pleading guilty and you are guilty of these offenses and all lesser included offenses, and all of that is true, so help you guys. So you're pleading guilty to paragraph 1, the state jail felony, and true to paragraphs 2 and 3, the prior burglaries of buildings of state jail felonies, which constitute here a state jail felony, punished though as it were a third degree felony. I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened today on all of this? All right, that is all.
Thank you.
For the record, that was not the actor, James Dean. That was an individual. Okay, Abel Garcia, please.
I thought you, I'm sorry, I thought you skipped one.
I did.
J Division. The bottom page.
Hold on. Jay DeVillier?
Yes, sir.
All right. Yeah, let's go, Jay.
Pavilion?
Yeah. Jay DeVillier.
See my offer on you?
Oh, yeah, it's coming from me.
Oh, okay.
You don't need to see him?
He's gonna plead.
No, it's a motion to revoke probation.
Moving on to the time.
Jay DeVillier.
Oh, no, I've already got it.
25 CR 729 is now called the state of Texas versus Jay Kennett. DeVillier, that's you?
Correct.
With your attorney, Mr. Dusler, and the state's attorney, there is a motion to revoke unadjudicated probation. It's been filed as of June 5th, 2026. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes, sir.
In summary, and raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Correct.
Lower your hand. In summary, this motion alleges that on August 4th, 2025, almost a year ago to the day here, that you in this court were placed on deferred or unadjudicated probation for 10 years for the second-degree felony of aggravated assault with a deadly weapon. Is all of that true and correct?
Correct.
All right. Number one states you failed to report to the Jefferson County Probation Office for the months of April and May of 2026 in violation of your probation order, which states you shall report regularly and monthly. Is that allegation true and correct?
Correct.
Are you pleading true and correct of voluntarily and because it is true as it is alleged?
Correct.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that would be enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked, you can be found guilty, and then sentenced up to the full range of punishment. This is a second-degree felony. You are on probation, or you are looking at no less than 2 nor more than 20 years confinement in prison. Understanding that, do you insist on pleading true today?
There's no agreement. You're pleading true to this and the judge to make a determination.
Oh, there's no agreement on this?
That's correct, Judge.
You understand the consequences, what you're facing. It's up to that amount, the
Right.
full range. No, I'm stating to you, knowing that, do you insist on pleading true today?
Sure.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. Here, allegation 2 is something we need to deal with. This states you failed to remain compliant with attending rehabilitation, treatment, residential, or counseling. You rejected the rehabilitation opportunities while you were in Baptist Hospital in May of 2026, and that violates condition 12 of your deferred or unadjudicated probation order, which states you shall attend rehabilitation, treatment, residential programs, and counseling as directed by your probation or officer and provide verification of such. Is that allegation true and correct as it is alleged? That you failed to remain compliant with attending rehabilitation treatment as ordered by the court?
I completed Baptist, but I did not go to
The rehabilitation?
rehabilitation.
Okay, why?
I was working a job and trying to make some money to pay off probation, and then I was going to afterwards.
Yeah, but the job is important. You know, it pays for things, but this gets you revoked and sentenced up to 20 years. It could. All right, is that allegation true?
Yes.
It's not true that you failed to remain compliant with attending rehabilitation treatment?
Sure. It is true. Okay.
Okay. Have you had enough time to think about it and talk to Mr. Dusler about all of this? Do you feel comfortable being up here?
I'm okay.
Okay. Number 3 states you failed to provide verification of performing community service hours as required. How many community service hours has he completed since August 4th of last year?
164, Your Honor.
Okay. How much did he fail to complete?
For the first year, he has to complete half of his 800 that were assigned.
Oh, 400?
Yes, sir.
Okay. What happened on the community service hours? What was he required to do for community service?
I asked him to come to the office. We have community service there that we offer. And I mean, he was compliant like once a month, but I really wanted him to come more often.
Okay. Are you pleading true to allegations 1 and 2 here, failing to report and failing to remain compliant with attending rehabilitation treatment? Are you pleading true to those 2 allegations voluntarily and because those are true as they are alleged, sir?
Sure.
You understand that a knowing and voluntarily made plea of truth of 1 or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can now be revoked. You can now be found guilty for this aggravated assault with a deadly weapon and sentenced up to the full range of punishment, which is no less than 2, no more than 20 years confinement. Knowing that, do you insist on pleading truth today? I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Sure.
Who is Jason DeVillier? How are you related to?
My father.
All right. There's no agreement on this.
That's correct.
So I'm going to ask the parties what y'all suggest. I'm looking at the criminal history summary based upon the public safety report that I have here. I don't have a pre-sentence report with me because we purged those.
I have the copy of the original PSI, Judge.
Okay. And it looks like the defendant has some prior convictions.
That's right.
Here of theft of property in 21. He was placed on probation. It's misdemeanor, placed on probation. That was revoked and sentenced to 30 days. Indecent assault was convicted and was sentenced to 90 days. Theft of property convicted 90 days confinement, all jail. Criminal trespass convicted 90 days confinement. 23 was not a real good year. And then let's see, criminal trespass to habitation, 90 days. Then also in 23 convicted 20 days, county jail in Angelina County, evading arrest or detention in 2025, convicted 40 days confinement. So, well, let's see, 1, 2, 3, 4, 5, 6 misdemeanors that I'm looking at. And then this deferred that he's on, but he was on deferred in 2013. I guess he successfully completed that. I guess. It doesn't say. Stand by. And there was an arson probation that he was on in 2017. I guess he successfully completed that. Okay, here, thank you very much. I knew the DeVilliers in Grove. I grew up in Groves. I knew John DeVillier and Russell DeVillier. That was your grandfather, maybe, or no? They have to be related somehow, but they would be older. They're older than me, but they knew my father better. But they were very, John DeVillier was a very famous newspaper sports writer for the area. And Russell DeVillier was a very well-respected man. Okay, so there's no agreement here. What do we do? Go ahead, Don, you can go first.
Judge, he's wanting to remain on probation, and
There's a way to do that, and that's not commit violations. Like you've admitted to here.
fortunately, there are no
How much
new,
time? Thank you.
fortunately, there are no new criminal offenses, and I think the probation officer correctly stated that, he's made attempts and he reports, but just not as regularly as he should. And he's done a bunch of his community service, but again, not as regularly as probation would like him to. I think because he's on the mental health initiative and that he's making attempts, we don't have any new offenses that would benefit not only him, but everybody in general, to have him continue to be monitored for probation. And we would ask that the court hold this matter in advance and allow him to continue on probation.
What state say?
Yeah, the court's hit on what I was going to hit on, which is the criminal history for this defendant. He is fortunate, given that criminal history, to have even been given this opportunity with community supervision. And the fact that he squandered that opportunity, Judge, and wasted resources that could be devoted to other defendants who would benefit from community supervision, I think is the real travesty here, Judge. This is not the first time that he should have gotten the message. There was an administrative hearing back in May of 2026, and that didn't get his attention, Judge. I'd ask that you revoke his community supervision, reform the judgment, and assess no less than 5 years TDCJ.
Sanction for 5 years. Imprisonment. This is your chance to speak if you wish, Mr. DeVillier. Can you explain all of these problems? And can you explain what kind of plan you might have to fix your decisions that you're making that are consistently wrong? You can fix it. I mean, what's right and wrong. What's causing the problems? We got to communicate here. I quit being a mind reader a long time ago.
Right.
What do you want to do? Do you want to go?
I would like to continue with probation.
Do you?
Fill it
Okay.
out.
This isn't the way to do it,
Right.
It's simple
That's
enough to
awesome.
revoke and sentence you and we move on. But how many chances do you get? We rattled off all kinds of convictions here for misdemeanors and then probation. If you don't report regularly, you're not on probation. We have to supervise you, and we can't come and find 5,000 probationers. We have 5,000 probationers at any given time. We can't go and look for you. You have to report. You have to do your part. If you don't report, you're AWOL. Were you ever in the military?
No, sir.
On your AWOL, they find you and put you in a rig, and they don't give you a medal. You're not on probation if you can't report. You got to do your part. You're on your own probation, which isn't the way it works. And then counseling here, you've got to help yourself fix the issues that you have so that you can be the very best you can be. But once again, we're not going to go find you like you're in the second grade because you lost your way to the classroom. You're an adult. You're responsible for doing your part. And we're going to make it available, but at the end of the day, it's you, the probationer, who has to do the heavy lifting, not the probation office. Or do you want me just to revoke and then you go to prison and then it'll get behind you after some years? But this is a aggravated assault, whatever you're sentenced to, because there was a deadly weapon use, you're going to have to serve 50% of your time. So if you're sentenced to 20 years, you're going to do a decade in prison, a decade. And you only have 89 days credit.
You think
That's a whole generation almost.
you think you could successfully complete probation, do what they've asked you to do? That's what we're asking the judge.
Right. Well, yes, yes, sir.
Oh, wait a second. Let me just refresh your memory. When we placed you on probation, you signed right here, right after my signature. I have received a copy of this probation order. I agree to follow all conditions imposed upon me, and I know that this community supervision can be revoked for any violation. What was this? I agree to follow all conditions imposed upon me. Here we are. You can imagine how your promises don't mean too much anymore. You had been on probation for a year. Here you are. Not doing the most important thing, and that's reporting regularly. Well, what state?
We're asking for revocation, Judge. No less than 5 TDC.
Okay. And probation.
Whenever he was given probation, his mom didn't want him to live with him, so he was staying at his grandma. He was working at Taco Bell for a good while up until February. And then his grandma called me and actually came to the office and said, hey, he got fired from Taco Bell because he stopped going because he was drinking at night. I didn't include this as a new violation because I never tested his alcohol because I never got a hold of him again. But his grandma kicked him out of his house. He was staying at hotels. So if he does get probation again, I'm not sure where he will stay. His mom didn't want him to begin with, and then his grandma kicked him out of her house.
Where are you going to stay if we continue you on probation? If we do that, where would you stay?
Yes, I didn't know I couldn't go back.
Oh, you just heard that for the first time?
Right.
Well, you can imagine, I mean, you know, why wouldn't they consider that after what's going on here? Fix this. Got a phone on in there. Yep. I don't want people, there's a big sign that says turn your phones off. And I'm looking at the guy's phone as he's walking out, but yeah. All right. Well, we can't put him on regular probation. Because he's got a deadly weapon finding. So it's either revocation or continue. I'm reluctant to send him to prison for a long time for these types of violations. But it's still a violation. It only takes one. He's on the mental health case law too. How's that working out?
He was doing fine up until February. And I don't know if he stopped using medication because...
Where are you working? Okay. Where are you working now?
Working now?
Yeah, if you're continued on probation, where are you working? Who do you
I'm
work
gonna work at Walmart. Well,
at? Walmart?
yes, sir. Walmart. Goodwill.
They're going to put you back to work if you were released?
Sure. Well, I would assume so. Yes, sir.
Here's what I'm going to do. I'm going to find if there is sufficient evidence supporting this motion to revoke probation to grant it by preponderance of the evidence or to greater as allegations belonging to or proven truth. I'm going to continue the defendant on this deferred or unadjudicated probation, you're going to do 10 more days in the county jail. Then you will be released and follow these terms of conditions of probation. They're there for your best interest, but all you're doing is shooting yourself in the foot by not reporting and not remaining compliant with the counseling. Those are vital. You can imagine next time you're not going to be given a lenient option. And once again, it's up to 20 years in prison, and this is 50% that you have to serve, which means a decade. But it's your choice. This is all, you're only here because you made a choice not to do the right thing, and you are able to do the right thing. Fix this for your own benefit. I mean, we're trying to help you. Fix this, please, or else we don't have another choice. Okay, that is all.
Thank you.
See the probation officer. Thank you.